So it is uh, polity Ghatna Chakra book, okay, and the chapter name is High Court. So the first question is, which among the following is not correct about the High Court in India? The first one says the second appeal to the High Court is within its appellate jurisdiction. Second one is every judge of High Court is appointed by the President. It is correct. All the judges of Supreme Court and High Court are appointed by the President. Okay, after the consultation of the required collegium. The next one is governor of the state appoints the judges of a high court. No, the governor doesn't appoint. It is appointed by the president itself. Okay, so C is wrong. Last one says High Court may accept a petition related to public interest litigation PIL. Okay, yes, High Court can accept petition related to PIL. So all are correct except option C, which says Governor of the state appoints the judges of a High Court, where the governor doesn't appoint the judges of the High Court. Uh, he can be consulted, but he doesn't appoint. He is appointed by the president. Okay, so the next question, let's check the answer. According to Article 217 1, every judge of a high court shall be appointed by the president by warrant under his hand and seal. So option C is wrong, while other options are correctly related to high court in India. The next question is the salary and allowances of the judges of the high court are charged to the. So the salaries and allowances of the judges of the High Court. Okay, High Court is charged from the Consolidated Fund of India, and the judges of the Supreme Court's salaries and allowances are also given from the Consolidated Fund of India. But the twist here comes that the pension, like when the judges of the High Court retires, they get the pension from the Consolidated Fund of India, okay. But the salary and allowances are given to the judges of the High Court from the Consolidated Fund of the state, okay. The salaries are given by the state, and the allowances, the pensions are given by the Consolidated Fund of India, okay. According to Article 202 3D, the salaries and allowances of the judges of a High Court are charged to the Consolidated Fund of state, but according to Article 1123D, they get their pension from Consolidated Fund of India. Whereas the option C, which says contingency fund is the emergency fund which is preserved for the emergency thing. The next question is the pension of a retired High Court judge is charged from the Consolidated Fund of India. The age of retirement of a High Court judge is, it is 62 years, okay. Oh, and that was done by the 15th Constitutional Amendment Act 1963. Though they tried to pass the bill related to the increment of the retirement age, uh, but it was not it but it lapsed, okay. So the age is still 62 years for the High Court judges and 65 years for the Supreme Court judges. The next one is there are 25 high courts in India. Yes, there are 25 high courts in India, and in which seven high courts share common high court, okay. Whether it is one or more state or one state and union territory. Among this, only Delhi and Jammu Kashmir are the two UT which have their own high courts. Okay, there are 25 high courts in India, correct. Next one is Punjab, Haryana, and UT of Chandigarh have a common high court, correct. The National Capital Territory of Delhi has a high court of its own, correct. Okay, 1, 2, and 3 are correct. Option C. Presently, there are 25 high courts in the country. High courts are instituted as constitutional courts under Part 6, Chapter 5, Article 214 of the Indian Constitution. Union Territory of Jammu and Kashmir have their own high court. It is the only union territory to to have a separate high court, while Punjab, Haryana, and UT of Chandigarh have a common high court. The next question is, consider the following statement regarding the high courts in India. The first one is, there are 18 high courts in the country. No, there are 25. Next one is, three of them have a jurisdiction over more than one state. Yes, seven of them have more than one state, means one state plus UT, or one or more than one state. Okay. No UT has high courts of its own. No, Delhi and Jammu Kashmir are the UT which have their own high courts. Next one is, judges of the High Court hold their office till the age of 62. Correct. So one is wrong, two is correct, three is wrong. Okay. So option 2 and 4 are correct. 2 and 4, where it is? 2, 2, 2, 2. Three of them have jurisdiction over more than one state. Seven of them have more than one state. So at least, if the word at least was there, then option 2 was correct. Okay, will be correct. But option 4 is obviously correct, and option 2, I don't know. Let's check. Yes, the answer is D, of 4 only. Their total number of high courts, the total number of high courts are 25 in India. Among these, seven have the jurisdiction over more than one state. Yeah, it is there. Okay, okay. In option number 2, it is given just only 3, they are trying to say, but it is 7, so the option 2 is wrong. Okay, 7 have the jurisdiction over more than one state's UT of Delhi and Jammu Kashmir have their own high court, thus option D is correct. Next one is, the number of high court of judicature in India is judicature is 25. Okay. when the when the chief justice of high courts acts in an administrative capacity, he is subject to when the chief justice of high court acts in an administrative capacity, he is subject to the writ jurisdiction of any of the other judges of the high courts, special control exercised by the chief justice of India, discretionary power of the governor of the state, special powers provided to the chief minister in this regard. Okay, I don't have much idea. Let's read the question again. When the chief justice of high court acts in an administrative capacity, he is subjected to the writ jurisdiction of any of the other judges of the high court. Okay. Answer is, the Chief Justice of High Courts acts in dual capacity, that is, judicial and administrative. In administrative capacity, the Chief Justice of High Court is subject to writ jurisdiction of any other judge of the High Court. He controls, observes, superintends, and administers the lower courts. So, question number 8. Okay, I'll take a screenshot and read it again later. Okay, so the next question is, the power of High Court to issue writs covers constitutional rights, yes, statutory right, yes, fundamental right, obviously, all of the above. Like, the power to issue a writ for High Court comes under Article 226, and for High Court it comes for High Court it comes under 226, while for Supreme Court it comes under Article 32. So, and the articles which explicitly talks about judicial review are Article 13, 32, and 226. There are various others, but these three are very important. Okay, so the answer is, the power to issue writs is given to Supreme Court under Article 32 and High Court under Article 226, whereas the area of control or the jurisdiction of High Court is more than Supreme Court in case of issuing a writ. Okay, and writ under Article 226 to issue a writ of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. The power of Supreme Court to issue writ is limited in Part 3 of the Constitution. Yes, that is what I was talking. But the High Court has right to issue writs for enforcement of any of the rights conferred in Part 3 and for any purpose, for any other purpose. Okay, so the power to issue writ for the Supreme Court is limited. Okay, but for High Court, they have more power in that case. Okay, they can in Supreme Court it can they can issue only for the fundamental rights, but in case of High Court they can issue it for legal rights also. Next one is habeas corpus. Habeas corpus means to have the body of. Let us have the body. So 1-4 mandamus talks about working. Oh, and let's check on the basis of habeas corpus. 2A4 answer. Okay, there are two. Okay, C and D. Let's check. Oh, habeas corpus. Mandamus is for the working. Okay, we command B3. Yeah, so option C is correct. Yes. Okay, habeas corpus means let's have the body of. Let us have the body. Mandamus we command, like we issue it for the like for example for an IS officer we can issue mandamus if he doesn't work or regulates his work properly. So mandamus is we command. Okay, prohibition means writ to subordinate courts. It is issued for the lower courts. Okay, a certiorari means be more fully informed. Quo warranto mean by which authority. Okay, quo warranto by which authority, certiorari be more fully informed. Okay, next one is which high court stated that the divorce by saying talaq 3 times is illegal. Okay, let's check the answer. Calcutta High Court, Allahabad High Court, Bombay High Court, Punjab High Court. So the answer is Allahabad High Court. Allahabad. Okay. Also a trick you can form here is the word Allahabad. Okay, Allah, like it is for the Muslim teen talaq, so it can go for the word Allah. Okay, so Allahabad High Court decided in the case of Rahmatullah versus State of UP 1994 that the divorce by saying talaq for 3 times is illegal. It violates Article 14 and 15. It is noteworthy that under the Muslim Women Protection of Rights on Marriage Act 2019, any pronouncement of talaq by a Muslim husband upon his wife by words either spoken or written or in electronic form or in any other manner whosoever shall be void and illegal. Next question is which one of the following high courts has the territorial jurisdiction over Andaman and Nicobar? Andaman and Nicobar. Okay, I don't know the answer well. So, Andhra Pradesh, Calcutta, Madras, and Orissa. So, the correct answer is option number B, that is Calcutta. Let me write this. Which of the following high courts has the territorial jurisdiction over Andaman and Nicobar? Nicobar. It is what? Calcutta. That is Kolkata. Okay. So, Kolkata High Court has the territorial jurisdiction over the Andaman and Nicobar Island, while Chandigarh comes under the jurisdiction of Punjab and Haryana High Court. Okay, Punjab and Haryana plus Chandigarh question was above also. Delhi has its own High Court, while Puducherry comes under the jurisdiction of Chennai. Puducherry comes under Chennai. Okay, and Lakshadweep comes under Kerala. Lakshadweep Kerala. Okay. Yeah. So the next question is, which of the following high court has its jurisdiction over more than one state or UT? Okay. Which of the following high court has over more than one? I don't know actually. Gujarat, Delhi, Allahabad, Bombay. Okay. So the answer is Bombay. Bombay High Court has its jurisdiction over more than one state. Okay. Bombay. Okay, and the states are Maharashtra, Goa, UT of Dadar and Dadar and Nagar, Daman and Diu. Next is, which of the following Indian state does not have its own high court? Odisha, Sikkim, Manipur, Himachal Pradesh. I guess Manipur. Let's check the answer. When this question was asked, Manipur did not have its own high court. It was under Guwahati High Court. High Court of Manipur was established in 2013. So all of these places have their own high court. Okay. So the next question is Guwahati, Manipur. Manipur has high court. Okay. 2013. And the thing of high court started from the institution of high court originated in India in 1862 when the high courts were set up at Calcutta, Bombay and Madras. Okay. In 1866 a fourth high court was established at Allahabad. Okay. So the thing of high court started in 1862. It was set up in three places, which is Calcutta, Bombay and Madras. Okay. And the fourth one was was originated or established in was established in Allahabad. Okay. Next one is, who became the Chief Justice of Chhattisgarh? Okay, this is not important. Next one is, in which of these states High Court were established in March 2013? So it is what? B, option B, only 2 and 4. Meghalaya and Mizoram. In January 2013, the Indian government established three new high court: Meghalaya, Manipur and Tripura. Okay. Three places. 2013 again. 13. Okay. Three places where one is Tripura. Okay, Tripura, Meghalaya and Manipur in 2013. In January 2013, the Indian government established three new high courts, that is Meghalaya, Manipur and Tripura in the northeastern states. These high courts started working from March 2013. How many high courts in India have jurisdiction over more than one state? That is 7. So it is given here, excluding the UT, that are three high courts have jurisdiction over more than one state. That is, Guwahati have over Arunachal Pradesh, Assam, Nagaland and Mizoram. Bombay have Maharashtra, Goa, Punjab and Haryana. Okay. Okay. I need to write this. That's why I took a screenshot. Next one is, which of the following high courts has the largest number of benches? So I think I read this somewhere. I don't remember though. Okay, so the answer is C and D, Bombay High Court and Guwahati High Court. The seat of the Calcutta High Court in Kolkata, the capital of West Bengal. The Kolkata High Court extended its circuit bench in Port Blair, the capital of the Andaman and Nicobar Island in Jalpaiguri, the headquarters of the Jalpaiguri division of West Bengal. Madhya Pradesh High Court seat is at Jabalpur, and two temporary benches are at Indore and Gwalior. Mumbai High Court had jurisdiction over the state of Maharashtra, Goa. Maharashtra, Goa, the UT of Daman and Diu, Dadra and Nagar Haveli. The court has benches in Nagpur, Aurangabad, and Panaji. The principal seat of the Guwahati High Court is at Guwahati in Assam. The court has three outlying benches. These are Kohima Bench for Nagaland State, as the Azawal Bench for Mizoram State, and Itanagar Bench for Arunachal Pradesh State. Currently, Mumbai and Guwahati High Court have three benches each. Okay, next question is, which one of the following subjects come under the common jurisdiction of Supreme Court and High Court? Option C is obviously correct. Both of them, according to they can issue writ for the for the violation of fundamental rights. For Supreme Court it is 32, and for High Court it is 226. So it is clearly clear answer. Okay. So if mutual dispute among states is there, it will be only for Supreme Court. Dispute between center and state, again for Supreme Court. Option C, protection for fundamental right, both. Protection, next one is protection from the violation of the Constitution. Hmm. Again, for the Constitution, it is. I'm not sure. Let's read the answer. Wait. Wait. So the answer is C. Matters regarding the protection of fundamental right comes under the common jurisdiction of Supreme Court and High Court. The Supreme Court under Article 32 and High Court under Article 226 have the power to issue a writ for the enforcement of any of the right conferred by the Part 3 fundamental right of the Constitution of India. It is to be noted here that Supreme Court is called the guardian of the Indian Constitution. Next question is, in which petition judiciary orders executive to perform their duty? Mandamus. Okay, for habeas corpus, it means to have the body of. Mandamus means to check upon, like we demand. Prohibition is for the courts. Okay. A writ of mandamus, which means we command in Latin, or sometimes mandate, which means compulsory, is the name of one of the prerogative writ in the common law. It is issued by a superior court to compel a lower court. Okay, yeah, to compel a lower court or a government officer to perform mandatory or purely ministerial duties correctly. Next is when the Supreme Court issues a writ to a person or to an institution to perform its duty, it is called mandamus. Which one of the following is not the main jurisdiction of the High Court of a state? Supervisory, advisory jurisdiction, original jurisdiction, supervisory jurisdiction, appellate jurisdiction. I don't know. According to Article 143 of the Indian Constitution, the advisory jurisdiction is the main jurisdiction of the Supreme Court, not of High Court. Okay, so this is important, which is advisory only for Supreme Court. Okay. According to Article 143 of the Indian Constitution, the advisory jurisdiction of the main jurisdiction of Supreme Court and not of the High Court. Which among the following is issued when the procedure is pending in court? Mandamus means they can check upon. Okay. Certiorari means what? Certiorari. Okay. It is related when the case is ongoing. Prohibition means to stop, to prohibit, as we say in common language. Quo warranto is again when the related to the court when it is already done. The yeah, the what we say, the outcome, the result, the, the judgment is already made. Okay. So option C is the correct answer. The writ of prohibition is issued when the procedure is pending in court. Okay. Writ of prohibition is issued when the procedure is pending in court. Okay. When the lower court hears any case out of its jurisdiction, the upper court takes over the case by issuing prohibition writ. Okay. Next is the writ of certiorari is issued by a superior court. Okay, yes, certiorari. Yeah. To an inferior court to transfer the record of proceeding in case for review, correct? To an inferior court to stop further proceeding in a particular case. Maybe, I don't know. To an officer to show his right to hold a particular office. No. To public authority to, no, that is D. C is for mandamus and D is for habeas corpus, and to stop is for quo warranto. To an inferior court to transfer the record of proceeding comes under certiorari. Okay, so the writ of certiorari is issued to a lower court directing that the record of a particular case be sent up for review together with all supporting files, evidences, and documents, usually with the intention of overruling the judgment of the lower court. It is one of the mechanisms by which fundamental rights of the citizens are protected. Okay. Transfer the case comes under which? It comes under certiorari. Surgery. In prohibition, they can take up the pending cases. Okay. The next one is, which one of the following writs examines the functioning of subordinate court? Okay. Quo warranto, mandamus, certiorari, habeas corpus. So sorry, so it is certiorari. Hmm. The answer is the writ of certiorari is issued by the higher court to a lower court to examine the functioning of subordinate court. The writ orders to deliver in a case so that the higher court may review it. Given below are two statements, one labeled as assertion and the other reason. So the assertion is willful disobedience or non-compliance of court orders and use of derogatory language about judicial behavior about to contempt of court. It is correct, but let's see the reason. Judicial activism cannot be practiced without arming the judiciary with punitive power to punish contemptuous behavior. I don't think it is the correct. Reason is wrong. I mean, reason is not wrong, but it is not applicable to this. I don't know. Let's check. So the answer, okay, yes. Both assertion and reason are correct, but the reason does not explain the assertion. So option B is correct. Yes. Both are correct, but they does not support each other. So judicial activism cannot be practiced without arming the judiciary with punitive powers to punish contemptuous behavior, willful disobedience or non-compliance of court orders, and use of derogatory language about judicial behavior. Okay. Next one comes assertion. The public interest litigation (PIL) permits public-minded citizen to reach the court of law. Correct. Next, the public-minded people may seek justice for the person who is unable to reach the court of. Correct. Both are correct. Yeah. Any citizen can go to court for justice regarding the welfare of any other person, group, or society through the public interest litigation. While for the general thing like the victim, the accused person can go to the court for justice, but in case of PIL, anyone can go regardless of the thing. Next is assertion. The scope of judicial review is limited in India. Yes, it is. Indian constitution is a bag of borrowing. It is also correct, but it is not somewhat related. Judicial review has been borrowed from the constitution of from US, and also the scope of judicial review is limited in India, whereas in US it has more uh, liberation, or it doesn't have narrow boundaries like India. Both are correct, obviously, but I don't think reason is the correct thing for that. Answer is B. Both A and R are correct, but R is not the correct explanation of A. Okay, correct. Assertion is correct because the scope of judicial review is limited in India. It has main three reasons. The judiciary reviews legislative function, especially if that law affects the basic structure of the constitution. Yes, um, in some of its distinguished judgment, the Supreme Court has defined the outline of sovereign power as distributed amongst the three branches of the government, namely the legislature, executive, and judiciary. Third is the huge size of Indian constitution also reduces the scope of judicial review. The huge size of okay reason okay. Next is assertion. High courts are in better position to protect rights of the high Indian citizen than the Supreme Court. Supreme Court can issue writ to protect the fundamental right only. Yes, correct. A is also correct. A has like high courts have more what we say bandwidth, but let's see the answer. Both A and R are true. R is the correct explanation of okay. Both the statement are correct according to Article 32 okay and 226 for High Court. Okay. What is the nature of the dispute of Babri Mosque Ram Janmabhoomi case before Allahabad Court? Writ petition, title suit, claim for compensation, judicial review. It is for title suit. Okay. It is not clear. Yeah, Ram Mandir is there. The dispute of Babri Mosque and Ram Janmabhoomi is presented before Allahabad Court as a case of title suit. Okay. Janmabhoomi. It is for title suit. Okay. In which two separate communities have claimed for the same land and property. Yeah. Next is according to the Constitution of India, the term district judge shall not include chief presidency magistrate, session judges, tribunal judge, chief justice of a small cause court. So it is tribunal judge. According to Article 236A, the expression district judge includes judge of a city civil court, additional district judge, a joint district judge, assistant district judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, session judge, additional session judge, and assistant session judge. The district judge shall not include the tribunal judge. Next is acting judge are appointed in where there are acting judges are appointed in both the places in Supreme Court and High Court both. And when the acting chief justice is appointed in the Supreme Court, it is called no, no. When the chief justice of acting chief justice of India is appointed, it is called acting chief justice of India, and the other judges of the Supreme Court is appointed, the acting one are called ad hoc judges, while in a high court they are called acting chief justice and acting judges. Okay, so option no, it is wrong. I was saying wrong. Acting judges are appointed in high court. Let's read the answer. Provision for appointment of additional and acting judges and the high court comes under 224 of the Constitution of India. But let me check the answer. According to Article 224, if by reason of any temporary increase in the business of High Court or by reason of arrears of work therein it appears to the present. Okay, let me check. Acting judge. Or acting judge. Let's check. Appointment of acting chief justice. Okay, acting judge. No, it. Oh, the word ad hoc is used. Okay. Yeah, yeah, yeah. Okay. 224 when any judge of. According to article no person. Okay. So the acting judge can be appointed by the chief justice of the respective court. That is high court. Next one is the term district judge is mentioned in which of the following article of the Constitution? It is mentioned in Article 233. The term district judge is mentioned in Article 233 of the Indian Constitution, which deals with the appointment of district judges. Okay. The next one is consider the following statement. The mode of removal of judge of High Court in India is same as that for the removal of judge of the Supreme Court. It is yes. For the removal of the judges of Supreme Court or High Court, it has to be initiated in any of the house. Okay, by the parliament. In short, by the parliament it is done. After retirement from the office, a permanent judge of a high court cannot plead or act in any court or before any authority in India. After the retirement, as the age is 62 years, and for the Supreme Court it is 65 years. So even if a judge of High Court retires, he still have 3 more years, and he can use that years in Supreme as a Supreme Court judge. So he can work actually. So only one is correct. Oh, the answer is according to Article 217 1b, a judge of High Court may be removed from his office by the President in the manner, and the removal and appointment is done by the President, okay, of the judges of Supreme Court or High Court. Provided in the clause 4 of Article 124 for the removal of a judge of the Supreme Court. So, statement 1 is correct. According to Article 220, no person who, after the commencement of this Constitution, has held office as a permanent judge of High Court shall plead or act in any court or before any authority in India except the Supreme Court and other High Courts. And other High Courts also. Okay. Next one is a High Court judge addresses his letter of resignation to the President. According to Article 217 1a, a judge of High Court may, by writing under his hand, address to the President, resign his office. Next is against which judge the Rajya Sabha passed the motion of impeachment in 2011, but he resigned to save himself before it could be passed by the Lok Sabha. And in short, no judges of Supreme Court or High Court has been impeached till date. So the answer is Justice Shaumitra Sen. Okay. Former judge of Calcutta High Court, Justice Shaumitra Sen, was charged for misappropriation, and the two grounds on which a judge of Supreme Court or High Court can be impeached are a misbehavior and incapability. Okay, so former judge of Calcutta High Court Justice Shaumitra Sen was charged for misappropriation of funds, so a motion of impeachment was passed against him in the Rajya Sabha in 2011. It was also presented in Lok Sabha on 5th September 2011, but he resigned from his post on 1st Sem 2011 before the bill was put in Lok Sabha. So it is Shaumitra Sen. Okay, let's write that. Shomit seen from where? Calcutta High Court. रिमूवल प्रोसेस चालू था. Okay. Next one is the mobile court in India is the brainchild of Dr. APJ Abdul Kalam. What is the thing? Mobile courts. Mobile courts. APJ. Former President of India Dr. APJ Abdul Kalam first imagined about mobile courts. The first mobile court of India was established in 2007. Okay. In Mewat district. 2007. Mewat district of Haryana. Mewat, Haryana. Wait. Okay. It was inaugurated by contemporary Chief Justice K.J. Balakrishnan. The concept of a mobile court is based on the pressing need to take the administration of civil and criminal justice closer to the people so that those living in remote area could benefit without incurring the expenses of traveling to courts at distant places. The next one is, who is the Chief Justice of High Court of Himachal Pradesh? So it is okay, not of our thing. Under preventive detention, a person can be detained without trial for 3 months. It is 2 months, but still it is ongoing for 3 months. Okay. According to according to Article 22(4) of the Indian Constitution, a person can be detained without trial maximum for a period of 3 months under preventive detention. Next one is, name the chairman of Law Commission who advocated the one-third of the judges in High Court should be from another state. So it is option C. Justice H.R. Khanna, the chairman of 8th Law Commission of India. Justice H.R. Khanna, in 80th report of the commission, recommended that at least one-third of the High Court judges should be from other state. It is called the method of appointment of the judge. The next question is, with reference to Lok Adalat, which of the following statement is correct? Lok Adalat have the jurisdiction to settle the matters at the pre-litigation stage and not those matters pending before any court. Lok Adalat can deal with matters which are civil and not criminal in nature. Every Lok Adalat consists of either serving or retired judicial officer, not only other person. None of the statement. Okay. The answer is D. The most important factor to be considered while deciding the cases of the Lok Adalat is the consent of both the parties. It cannot be forced on any party that the matter has to be decided by the Lok Adalat. However, once the parties agree that the matter has to be decided by the Lok Adalat, then anybody can move. Okay. Next is, with reference to the Gram Nyale Act, which of the following statement is correct? As per the Act, Gram Nyale can hear only civil cases and no criminal cases. The Act allows local socialist activities as mediator reconciliators. Option B is correct, only two. According to Section 11 of Gram Nyala's Act 2008, the Gram Nyale shall exercise both civil and criminal jurisdiction in the manner and to the extent provided under this act. So statement 1 is wrong, while according to section 27, the district court shall in consultation with district magistrate prepare a panel consisting of the names of social workers at the village level. So it is done.